बिस्मिल्लाहिर्रहमानिर्रहीम। वेलकम टू द शो। मैं हूं आपका मेज़बान रियाज गुल। नाज़रीन, एवरी मंडे 6 to 7 PM मैं लेके आता हूं लीगल शो, जिसमें मैं आपकी लाइव फ़ोन कॉल लेता हूं और आपके साथ शेयर करता हूं इमिग्रेशन लॉ एंड ह्यूमन राइट्स। नाज़रीन, हमेशा की तरह हमारे साथ कुछ मेहमान होते हैं जिनके साथ हम ये लीगल पॉइंट ऑफ व्यू पे बात करते हैं। लेकिन आज की जो मेरी मेहमान हैं वो इमिग्रेशन और में काफ़ी एक्सपर्ट, बहुत सारे केसेस उन्होंने डील किया कोर्ट में भी और बाकी मामलों में भी, और उनकी जो मेन एक्सपर्टीज़ है वो है एम्प्लॉयमेंट लॉ के ऊपर और इमिग्रेशन लॉ पे, स्पेशली इन Tier 1 बिजनेस वीज़ा और उसके बाद वर्क वीज़ा स्पॉन्सर लाइसेंस। लेकिन इसके साथ साथ क्योंकि हमने लास्ट वीक आपको अनाउंस किया था कि इस वीक हम डिस्कस करेंगे फॉर द डिपोर्टेशन कि डिपोर्टेशन क्या होती है। बहुत सारे लोगों का ये क्वेश्चंस आते हैं कि अगर किसी के ऊपर अनफॉर्चुनेटली कोई उसकी पेनल्टी हो जाए या फ़ाइन हो जाए तो क्या उसके रेपुटेशन उस पर इफेक्ट करती है, या होती तो फिर उस पर कैसे चैलेंज किया जा सकता है। तो इससे पहले कि हम आज के सवाल जवाब शुरू करें, पहले मैं वेलकम करता हूं हमारी गेस्ट बैरिस्टर नबीला मलिक को। मिस नबीला, थैंक यू टू कम इन टू आवर शो।
Thank you for having me, Riaz.
Okay, thank you, Miss Nabila. Miss Nabila, I think as we mentioned last week and announced to the public, we're going to be discuss for this week only for the deportations. So could you just briefly tell us, to my viewers, how, if anybody have a deportation order, so how they can challenge?
Well, a deportation order is firstly something that needs to be understood.
Yep.
And what that requires is the foreign national, somebody who's not British by nationality,
Right.
to leave the United Kingdom.
Right.
And before the person is deported, they can be detained by the Secretary of State in one of the immigration detention centres.
Of course, yeah.
And that's to allow the removal of the person from the United Kingdom.
Yeah.
And the purpose of the deportation order is to say you are being removed from the United Kingdom because you've been involved in a criminal offence and you cannot enter the United Kingdom as long as the deportation order remains in force.
Right.
And a deportation order can come under the immigration rules if the Secretary of State thinks it's in the public interest, or automatic deportation.
Normally we heard a very common is automatic deportation and then forced deportation. Was it different for that?
Well, there is automatic deportation was introduced by legislation.
Right.
And the legislative framework, the law that governs it,
Right.
Indicates that if you've committed a crime that carries a sentence of
Right.
1 year or more, you are subject to a deportation, automatic deportation order.
Right.
And that is that the Secretary of State removes you from the United Kingdom, except if there is a contravention by removing you
Right.
to your right as a refugee,
Right.
or your human rights.
Right. So Nabila, just the second question linked to the same question. So if anybody have, let's say, the sentence or the fine more than 12 months and less than 4 years, does they have any remedy to be just challenged within the country?
They do, and you're right to look at the different periods of time because, of course, there is legislation that governs how much weight one gives to Article 8
Right.
and the relationship with a relevant child in the United Kingdom,
Right.
etc. And that really, if you have stronger chances of remaining in the United Kingdom because of Article 8 rights if you've committed a crime less than 4 years than if you've committed a crime of 4 years.
But if the 4 years, there's no chance, right?
If you've committed a crime that carries a sentence of 4 years and more,
then there's no chance.
well, there's always a chance because
it's very hard.
Remember, the Refugee
Right.
Convention overrides
The immigration rules.
the immigration rules and other statutory provisions. So
Right.
if there's a contravention because of statute, because of asylum or because of human rights in relation to Article 3 being breached, Article 3 being that if you're removed to another country, you're at risk of being killed or seriously harmed.
Nabila, there's a lot of people on the phone call, but before I did a phone call, last question is just only this deportation for the people who have a limited leave to remain or without visa, or if anybody have, let's say if anybody have an indefinite leave to remain, Oh, unfortunately, he was imprisoned for more than 12 months, less than 4 years. Does he can challenge?
Deportation orders, once they are issued by the Secretary of State,
Yep.
Applies irrespective. They apply to people who are non-British nationals. So if you don't have
Right.
British nationality, you can be removed by a deportation order.
Right.
And that applies whether you have limited, exceptional leave to remain or indefinite leave to remain.
We have a lot of people on the phone, I think, on the queue. Let us take the phone call. Hello.
Hello.
जी फरमाइए.
Yes, thank you, sir, for taking my call.
Yeah, please.
I've got a very quick question on, I was on Tier 2 Visa General
Right.
and I applied for settlement last week under my premium service, which was on the same day, on 20th November.
Right.
And मेरे डॉक्यूमेंट सारे क्लियर थे, सब कुछ प्रॉपर थे, कोई प्रॉब्लम नहीं थी. And they still gave me a letter saying that they need further inquiry.
Yep, right.
And they didn't tell me what inquiry is on that, but my case was very straightforward. It was very clear from my end. All my documents were
Okay, so
meeting
did they take any decision or they just hold the file?
सर लेकिन उसमें ये प्रॉब्लम मतलब मुझे ये नहीं समझ में आया क्योंकि मेरी जो जॉब सैलरी जो थ्रेशोल्ड है that is under my SOC code is 36,500 and my salary is 36,600.
Okay, madam, may I ask one question? May I ask you, did they took the decision or they just hold your file?
So they just gave me a letter saying that they need further inquiry.
Okay.
Application is valid. The letter says the
Can you
application
hear or
is
not?
valid.
I can't hear because
Okay, no problem. I think let me put the speaker on meantime. Control if you just put the speaker in the room. But meantime, madam, I think you're going for the same day for the indefinite on the base of the tier 2. The Home Office, they have a right to just say, okay, we will hold your case and there need to be a further investigation. Maybe they just try to contact your employer or they want to check your any educational certificates or your employer certificates, and maybe they just want to be clarified by the HMRC. Also, you need to wait now because you done all the what you are responsible to do and you submit all your documents in support of your application. Now wait for their decision. Whatever they take the decision, they definitely inform you.
However,
Yeah,
if they are conducting inquiry, and there are issues that you can yourself see, it would be a good idea if at this stage you yourself explained any discrepancies that there are in the documents. Now, if this is an inquiry that involves the HMRC, it may be that there are discrepancies in the accounts that have been tendered and the representations that you've made.
But I think at this stage, just don't worry, just wait for the decision, and if they have any query, they will let you know. Thanks for your call. बढ़ते हैं next call की तरफ. जी फरमाइए.
But I think at this stage, just don't worry, just wait for the decision, and if they have any query,
Hello.
next call, बढ़ते हैं next call की तरफ. जी फरमाइए.
Hello.
I think we're having some broadcasting difficulties
Hello.
here.
हेलो अस्सलाम वालेकुम
जी वालेकुम अस्सलाम जी.
सर मैंने एक क्वेश्चन करना
जी पूछें भाई.
मैंने जो है ना फैमिली अप्लाई करनी थी पाकिस्तान से.
ओके.
मेरे पास जो है ना नेदरलैंड का पासपोर्ट है. तो उसके लिए मुझे कौन कौन से डॉक्यूमेंट्स चाहिए होंगे और उसके अलावा मुझे यहाँ से जो डॉक्यूमेंट्स भेजने पड़ेंगे अपनी फर्ज करेंगे जॉब कॉन्ट्रैक्ट वो ओरिजिनल भेजना है या फिर कॉपीज भेजनी, और कॉपीज भेजनी तो वो अटैच करवा के भेजनी या विदाउट अटेस्टेशन करवा
ठीक.
भेजनी.
आई थिंक मुझे लगता है कि आप यूरोपियन हैं और आपके पास यूरोपियन नेशनलिटी है. यूके में आप एज ए होस्टिंग कंट्री में अभी यहाँ स्टे किया हुआ है और यहाँ पर अपनी फैमिली को बुलाना चाहते हो. ये क्वेश्चन आपका जी. आई थिंक कॉल ड्रॉप हो गई. आप मेरा ख्याल है अंडर द यूरोपियन लॉ अपनी फैमिली को यहाँ पे स्पॉन्सर करना चाह रहे हैं. जो लोग यहाँ पे यूके में एज ए यूरोपियन रह रहे हैं उनको दो चीज़ें इस्टेब्लिश करनी होगी. नंबर एक कि वो यूके में रहते हुए अपने यूरोपियन टीटी राइट्स को एक्सरसाइज कर रहे हैं, और नंबर टू उनका जो रिलेशनशिप है उनके फैमिली के साथ वो स्टिल सबसिस्टिंग है और जेन्युइन है. और इसके अंदर जो भी चीज़ें आती हैं, मैरिज सर्टिफिकेट होगा, बाकी डॉक्यूमेंट्स होंगे कि रिलेशनशिप के तौर पे, और जो आपका काम करते हुए यहाँ पे एम्प्लॉयमेंट, उसकी वेजेस स्लिप्स, P60s, एम्प्लॉयर लेटर, ये प्रूव करना होगा. ये दो चीज़ें हैं बेसिक प्रिंसिपल. लेकिन ऑन टॉप ऑफ दैट एज ए जनरल टू सेटिस्फाई द इमिग्रेशन फीस sir, you need to be sure that you have a sufficient accommodation, कि आपके पास accommodation है उसको accommodate करने के लिए, और अब आपका जो future intention है to settle in the UK, not to go to the your Switzerland. अगर ये चीज़ें पूरी करते हैं तो आपको तमाम जो डॉक्यूमेंट्स हैं वो ओरिजिनल भेजने पड़ेंगे, सवाए आप अपना जो पासपोर्ट होगा उसकी कॉपी सर्टिफाइड करा के साथ अटैच करनी होगी, तो तब आपकी एप्लीकेशन को प्रॉपर कंसिडर किया जाएगा. Nabila, is that thing, or want to add something else?
I don't know where in the EEA
Okay.
the individual
Right.
concerned has come from,
Right.
because it has to be, obviously, for the EEA regulations to
Certainly.
apply,
Yep.
it has to be in the EEA territory where they are bringing their family from.
Right.
But you know that under Regulation 11 of the 2016 regulations, the individual, if he's married to to an EEA national and they're coming from the EEA, can come to the United Kingdom without having made an application beforehand, and they have 3 months in which to present their documents in order to satisfy the Secretary of State that they're entitled to a residence permit in the United Kingdom. The principal person must qualify as somebody who's working in the UK, so exercising their EEA treaty rights whilst being in the United Kingdom. But just to touch upon one of the points you made about sufficient accommodation, one must bear in mind that if you've got adequate accommodation, it must be accommodation that complies with the housing provisions. So you can't have overcrowding. You can't have 2 bedroom, for instance, and have a family of 8 people living
Sufficient
there.
accommodation मतलब ये कि आपके पास sufficient accommodation हो, but again इसके बावजूद हम advise करते हैं कि better होगा, क्योंकि ये आपका बच्चों का और family का matter होता है. So it's best कि before you make the application आप किसी solicitor को मिलें, advice ले लें, या उस किसी representative के साथ बात कर लें, ताकि आपकी application में कोई problem ना आए. आपकी कॉल का शुक्रिया लेते हैं. नेक्स्ट कॉल जी फरमाइए. हेलो
हेलो
जी फरमाइए.
जी, मेरी बच्ची यहाँ बॉर्न हुई है, वो 4 इयर्स ओल्ड है. स्टेटस की एप्लीकेशन करनी है, वो हो सकती है कि 5 इयर्स का लो है.
और आपका स्टेटस क्या है जहाँ पे जी?
मैं लीव टू रिमेन है मेरा, 2.5 साल वाला.
2.5 साल वाला वीजा आपके पास है, और अब
10 साल वाला.
ओके. एंड नो, आपकी जो बच्ची है वो 4 साल की होगी, राइट?
4 साल की हुई है.
और उसका वीजा है उसके पास 2.5 साल का?
हाँ, वो 2.5 साल का इसका वीजा तो है.
जो 5 साल वाली कैटेगरी है मेरे भाई, वो आती है स्टेटलेस बच्चों के लिए, क्योंकि आपने बच्चे का वीजा अप्लाई कर लिया तो ऑफ कोर्स आपने उसकी नेशनलिटी जो है वो रजिस्टर करवाई होगी, या उसका कोई आईडी कार्ड, या आपने कुछ डिक्लेयर किया होगा कि वो किस कंट्री से है या क्या उसकी नेशनलिटी है. तो जो 5 साल वाली कैटेगरी आती है वो स्टेटलेस बच्चों के लिए आती है. अब आपको उन्होंने 2.5 साल के वीजे पे लगा दिया, तो आइडियली अगर बच्चा यहाँ पे पैदा हुआ और 10 साल का हो जाए तब अप्लाई कर सकते हैं, या आप जो 2.5 साल की आपको लीव मिल चुकी है इस पर आप 10 साल पूरे करेंगे तो तब आप क्वालिफाइड करेंगे कि आप उसकी नेशनलिटी आपका यहाँ पे इंडेफिनिट उसके बाद नेशनलिटी अप्लाई कर सकें. आपकी कॉल का शुक्रिया लेते हैं. नेक्स्ट कॉल जी फरमाइए. हेलो
हेलो, नमस्कार सर.
जी नमस्कार जी.
सर, मैम से और आपसे मैंने क्वेश्चन करना था इमिग्रेशन के लोकर से.
प्लीज.
सर, एक्चुअली मुझे होम ऑफिस ने एक लेटर सेंड किया है, तो जिसमें रिक्वायरमेंट्स मांगते हैं, जीपी, डॉक्टर, काउंसिल टैक्स की, ऐसे उसमें सारी रिक्वायरमेंट पूरी करना पड़ता है या कुछ डॉक्यूमेंट्स देने पड़ते हैं?
आपका वीजा कौन सा अप्लाई किया आपने?
सर, मेरे को 15 साल हो गया यहाँ पे आए हुए. स्पॉस वीजा पर आया था, मैरिड था. तो अभी मैं डिवोर्स हूँ, मेरी बेटी है 13 साल की. तो अभी मैंने इंडिपेंडेंट अपना डाला हुआ है स्टे के लिए.
आपने ओके, मुझे सवाल है, बच्ची के पास वीजा कौन सा है?
नहीं, बच्ची के विदआउट किया, पहले किया था बच्ची के बेस पे, तो उन्होंने थोड़ा वीजा दिया था फैमिली प्रोसीजर पे. तो अभी मैंने खुद डाला हुआ इंडिपेंडेंट अपने बेस पे.
So what you're saying,
please.
so you've been here for a long time now, but you're under the 20 years mark, so you can't qualify for the 20-year period.
That is, I think, understandable.
However, you do have a child here in the United Kingdom. She, I think, has been here for over 7 years and is under the age of 18. In which case, if she may have nationality, if her father is British, under Section 1 of the British Nationality Act, she may not if you didn't obtain British nationality for her, but she may have right to live here because her father had a family right, and therefore she was a dependent on his application. In those circumstances, you are applying independently, therefore not together with your child, as I understand it. In which case, you have to argue that you're a primary carer of a British national. meaning that your child is British and you care for that child. If you cannot prove that, then you have to apply under Article 8 rights, and you have to argue there are exceptional reasons why you need to be here. And one of the exceptional reasons is a bit like arguing if the child were a British child, and that you are the primary care of the child, and the child needs to remain in the UK, and it's unreasonable to expect the child to leave the United Kingdom and accompany you to your home country. So these are the arguments that you can put forward. I would put forward that such an application isn't as easy or straightforward as you might think it is. Therefore, I think it's important that you go to see a solicitor, because a solicitor will complete the application form, ensure all the relevant information is provided, but more importantly, provide a cover letter explaining your circumstances, the historical background, and the reasons why you say that you should have a right to stay here now.
आपकी कॉल का शुक्रिया नाज़रीन। टाइम का छोटी सी ब्रेक का। वेलकम बैक आफ्टर द ब्रेक। नाज़रीन, हम लोगों ने लास्ट वीक जो बात की थी स्पॉन्सर लाइसेंस की थी कि जो लोग यहाँ पे बिज़नेस कर रहे हैं, जिनकी कंपनी है, अगर वो अपने किसी एम्प्लॉय को जो ब्रिटिश, नॉन ब्रिटिश, नॉन यूरोपियन हो, अगर उसको हायर करना चाह रहे हों तो उसका प्रोसीजर क्या है? उसके लिए ऑफ कोर्स स्पॉन्सर लाइसेंस अप्लाई करना पड़ता है। अब अनफॉर्चुनेटली अगर इसके अलावा कोई प्रॉब्लम ये आ जाए कि उनके पास कोई इलीगल वर्कर किसी रीज़न से काम करता हुआ, हम इनकरेज नहीं कर रहे हैं, लेकिन कोई कर रहा हुआ हो, तो अगर किसी न किसी जगह पे होम ऑफिस वाले आके उनको पकड़ते हैं तो क्या होता है? तो आज मेरे ख्याल में बिफोर इट अदर कॉल्स वी विल डिस्कस ऑन दिस पॉइंट विद Nabila. Nabila, a lot of people, I think my clients, they have issues because even if they have hired the people, they say okay they're legal, but after some time the home office come, they raise right, and they found this illegal. Does they have any, how they can challenge? And because the problem is not for the penalty, the fine, the problem is the home office can say shut down the business.
Yeah.
So on that part, they were in critical situations.
Yeah.
What your advice to them?
Well, employers who are employing any person from any nationality, whether they're British or foreign nationals, have to conduct checks.
Of course,
And there are two types of checks. There's one called the List A check of documents and List B, depending on whether the individual is permanently a resident in the United Kingdom seeking permanent employment, or temporarily resident seeking temporary employment. Usually you will have for both List A and List B, you'll have to ask for the passport with the relevant immigration stamp in there. And these are documents that must be properly kept in the employee file. So if there's an inspection, these documents will be to hand in order to hand over to the immigration officer. But of course, if you haven't carried out checks and you are caught employing illegal, and I use the word illegal because that's a statutory phrase, employees who aren't entitled to be in the United Kingdom with leave, then you could be fined up to 20,000 unless you have a defence, and in a defence you have to be able to show that you carried out the checks, but you were yourself given documents that you believe to be genuine, but they were fraudulent, etc. That's a kind of
but let me put the scenario. Let's say if the employer check all the documentations and the status before they employ the staff, there was legal and everything was accurate, but after some time the visas run out and they not have the valid leave to remain, what is on that stand if on that day the home office come?
Okay.
Because initially they check all the documentations, but done the regular review and the proper checks up to the expiring of the visa. So if on that day, the day the home office come, they have no visa and illegal, what is does the employer have any remedy on that part?
There is mitigating circumstances that can lead to a reduction of the fine that's imposed by the Secretary of State. Now, that again involves you getting legal advice and there being your mitigating circumstance being presented to the Secretary of State. So you're putting forward how it is that you came not to check these documents. But you have a duty to conduct checks not only at the commencement of employment, but also at the time that your workers' leave is due to expire. You should ensure that you have a proper
checks.
organised file for your employee that allows you to know when these checks or reviews have to be conducted by you. Because the whole point of these checks is that you as the employer stepped into the shoes of the Home Office. So you've got to ensure that the employee has the right to be here.
Now, what is happening is, if God forbid, if any employer find that he have employed any illegal, and then if they try to make the sponsor license, the Home Office is not allowing the sponsor license. They're
No.
saying, okay, because you've not done in the proper all the employer conduct in the past, then how we expect you will be in the future as well.
That's exactly the point.
Yeah.
The sponsor has got to be an employee who's highly trusted by the Secretary of State for the Home Department, because the Home Office want to be reassured that the person who is the employee that's conducting the checks is somebody who's capable of doing that task, and is somebody who's always been quite wary of employing somebody who's not entitled to be here in the United Kingdom. So yes, if you've had fines imposed upon you,
So
you're
what is
unlikely
your
to be,
advice, just in two
allowed to
words?
sponsor.
So what is your advice for the 2 words to the employee?
Before you, first of all, it's important for you to know, as an employer, what checks need to be conducted, and therefore you must get legal advice on this, because that one occasion when you're getting legal advice will hold you in good stead for any future employment that you embark upon.
So first, on the initial stage, when you employ someone, you have to check properly all the documents, and the second, you have to be regular checks. But if you want to be hired someone else, you need to make the application for the sponsor license. Is that the conclusion? Let us see the calls, Ms. Nabila. Hello. Hello.
हेलो
जी फरमाइए.
हेलो रियाज सर, मैं पहले तो आपका थैंक्स बहुत बहुत, आप हेल्प करते हैं सबकी.
वेलकम जी, बहुत शुक्रिया जी.
मेरे 2-3 सवाल हैं. हमारी अपील होम ऑफिस ने अपील विड्रॉन कर ली थी जुलाई में, 4 महीने से ऊपर हो गया. ओरिजिनल डिसीजन उन्होंने विड्रॉन कर लिया था.
राइट.
और उनके बाद 4 महीने से ऊपर हो गया, अभी जवाब नहीं आया कोई. हमको अभी क्या करना चाहिए? हमने कंसेंट वगैरह भी दे दिया, उसको भी 90 दिन हो गए और 90 दिन से ऊपर हो गई.
चलो आज हम ज्यादा बातें करते हैं डेपोटेशन के ऊपर या टी स्पॉन्सर लाइसेंस पे, लेकिन क्विकली बता दूं कि अब वेट करें, इस पे कोई टाइम लिमिट नहीं है. लेकिन इफ केस के 6 महीने से ज़्यादा वो रिप्लाई नहीं करते तो आप अपने वकील को बोलने कि उनको लेटर लिखें, फ़ोन कॉल करें, और अगर इससे भी ज़्यादा टाइम हो जाए तो आपके पास राइट है कि आप उसको बोलें, पेटिशन प्रोटोकॉल करें कि उसको थ्रेटनिंग लेटर भेजिए कि अगर आपने डिसीजन ना लिया तो मैं आपको कोर्ट में लेके जाऊँगा. आपकी कॉल का शुक्रिया. लेते हैं नेक्स्ट कॉल. जी फरमाइए.
हेलो.
हेलो
जी गुल साहब.
जी फरमाइए मेरे भाई.
जी सर, ऐसा है कि 2016 में मैंने टाइप एंड जनरल के ऊपर अप्लाई किया था ILR के लिए.
ठीक.
तो मेरा रिजेक्ट हो गया. तो फिर मैंने 10 साल के ऊपर अप्लाई कर दिया.
ठीक.
तो उस 10 साल के ऊपर जब मैंने अप्लाई किया तो उसके ऊपर उन्होंने 3225C लगा के वो रिजेक्ट कर दी. तो मैं अपील में चला गया.
ठीक.
मैं अपील में जब गया हूं तो अपील मैंने विन कर ली क्योंकि मेरी कोई टैक्स अमेंडमेंट नहीं थी.
ठीक.
अच्छा, अब इस बात को, अच्छा वो अपील मेरे हक में हो गई. जब अपील मेरे हक में हो गई, इसको 6 वीक हो चुके हैं, तो होम ऑफिस ने अपर ट्राइब्यूनल में जाने का सोच लिया. यानी कि वो कह रहे कि नहीं, हम
लेटर आपको आ गया कि नहीं आ गया? लेटर आपको आया कि नहीं?
अब ये अब
What he's saying is, the Home Office have appealed against the successful win of yours with the first tier tribunal. It's been 6 weeks. You're now waiting. You have to wait for the case to be listed, and your lawyers will be in touch with you to tell you about your the date that you are going to be heard at the upper tribunal. It may be that the upper tribunal do not give the Home Office permission to succeed, but here I suspect that the Home Office have identified a error of law made by the first tier tribunal, and that has to be argued before an upper tribunal judge, and a decision has to be made. So really this is something that you have to consult your legal advisors about.
Yeah, the better I think you should talk to the solicitor or the wait, because the case is going to be listed and then they inform you by the solicitor. Thanks for the call. Let's have next call. जी फरमाइए. Hello.
Hello.
जी फरमाइए.
Yes, Mr. Riaz. A quick question from you. So I applied for an ILR application from Tier 2 last week.
Okay.
And it has further gone into further checkings now, into further inquiries. So my question to you is, my company is being taken over by some other company next month. And I don't know what my status will be in the meanwhile, because if that
Okay, I think about the
happens,
Nabila will answer. Nabila, please. Okay, please.
And I don't know if I can apply for a different job in the meanwhile, because I've already submitted an ILR, and will that job be a
No,
sponsored
you don't
job,
need to
or
be the
can I have
application.
a non-sponsored job?
Okay, thank you. It's an interesting question now.
I think that is an interesting question.
Yeah.
What has happened is that your company that is being taken over, you remained with the company. So there is something called, under the employment legislation, a 2P transfer. And so what happens with the 2P transfer, if it's a business transfer or if it's a service provision change, so things are being done differently. And what happens in those circumstances is that you remain, and the new employer carries on the liability, responsibility for you. However, where there is a 2P, your employer is responsible for informing the Home Office that there is this change in the employer, and you're responsible for informing the Home Office that your sponsor is now being that employer is being changed. So you have to inform the Home Office that is happening. So there is a responsibility
So Nabila, here the one
both
question is,
employer
let's say
and yourself.
Let's say that the new company is taking over his company. So if they have no sponsor license, then where he stand?
Well, the point is that if they don't have a sponsor's license,
The new company, he's emerging now.
He's-
If they have no sponsor license, then how does they?
This is a bit more complicated. It's
Yeah.
not so straightforward because effectively he would have to be made redundant.
Yes.
And the employer he'd be made redundant by the company that he's transferred to,
Yeah.
and that employer would have a defence against any unfair dismissal claim
Yeah.
that he brings. So this is part of something called the Regulation 11, I think,
Right.
of the 2B provision consultation. This is something that he will have to discuss with his employers.
So it
They
means-
will have to consult with him. They'll have to inform him as to what they have done to inform the Home Office as to what is happening. Any sponsorship license, he can ask for during the consultation process that the sponsorship license be that there'd be a sponsorship license being
So
applied
just for the argument, so
by
I'm just
his
asking the
future
question on the
employer.
behalf of the client. Okay, if just for the arguments, they don't have a sponsor license, and does the Home Office give allowing him to some certain time, 60 days or 28 days to get a sponsor license to then TP?
Well, as I said, that this is slightly different from the 60-day period that students get when they lose their educational
License, yeah.
sponsorship
Yeah.
license, and they're having to then go to another educational institution. They're given 60 days
Right.
by the Home Office to make that application. This is slightly different because here you've got a business that's transferring. There's a whole piece of legislation that governs the transfer and how it's conducted and consultation. The consultation allows the employee to say, hang on a minute, I'm a foreign national, I'm employed through a sponsorship license.
Yeah.
Will my future employer, the business that is to be
Have a sponsor
transferred to, apply for a sponsorship license? And he will obviously want them to apply for that sponsorship license
All
in
right.
order for him to be employed by them.
I think so. I think the simple answer: first, you already made the application. Wait for the decision. If in case you don't get the positive response by the companies emerging to the new company, then I think your company and you should have to discuss the new company and have to inform the Home Office for your stance. Otherwise, it's going to be a problem. Thanks for your call. लेते हैं next call. जी, I think control से sections. Time is break. मिलते हैं छोटे से वक्फे के बाद. वेलकम बैक आफ्टर द ब्रेक। नाज़रीन, आज हम बहुत सारे डिफरेंट टॉपिक्स को डिस्कस करने की कोशिश कर रहे हैं। जैसे हमने स्पॉन्सर लाइसेंस की बात की है, Tier 2 पे बात की है। इसी तरीके से जिन लोगों के पास अगर अनफॉर्चुनेटली कोई इलीगल एम्प्लॉय हो तो उसके साथ अगर कोई प्रॉब्लम आता है तो उनके पास क्या क्या रेमडीज़ हैं, ये हम या कैसे वो इस मैटर को डील कर सकते हैं, या उसकी क्या रिस्पॉन्सिबिलिटीज़ हैं टू चेक्स द एम्प्लॉयज़ स्टेटस, इस पे बात हो रही है। लेकिन क्योंकि ड्यूरिंग द प्रोग्राम्स कुछ दोस्तों ने मैसेज किया कि उन्हें प्रोग्राम अच्छा लग रहा है, थैंक यू, उनका शुक्रिया। लेकिन साथ ही साथ एक क्वेश्चन है कि Nabila, my one of I think the friends or client, he just viewer, he texts me a message relevant to the tier 1 entrepreneur visa.
Yeah.
He is saying that a lot of his one of friend, he's applied the visa, he meet the criteria of the 200,000 pounds, he get the marks, and he also awarded for the educations and his English certificates, and the same time the maintenance as well. But unfortunately, they refuse application due to they say they're not satisfied his genuineness to come in the UK as an investor.
Yeah.
This is very ridiculous
It
because
is.
how they can.
It is. You say it's ridiculous, but the thing is that they obviously has a reason provided by the Secretary of State, which is why really entrepreneur visas have to be prepared. The application has to be prepared well with legal advice from both your home country in terms of how you transfer money from that home country and legal advice in the United Kingdom from those who can prepare your application well and ensure through their own experience what issues could arise, because guidance is being updated all the time. And you have to ensure that when you're making your application that you're complying with up-to-date guidance.
In this matter, he says he awarded the 95 points, 75 for the investment, 10 for the English certificate, 10 for the maintenance, but they just only refuse. They have answered 2 questions, and they say the suspicious is not satisfied for their intention to bring or to invest in the UK. Only just suspicion is not a sufficient argument.
But remember, you can seek administrative review and address any reasons for refusal given. The Secretary of State can't just refuse your application. There's a statement of reasons that is provided to you, and you have to address those reasons in your administrative review.
That is my question. So if he go for the admin review, sorry to interrupt you, but this question for client. So if he go for the admin review, is there chance they can accept?
Well, administrative review is as good as the person who has drafted the chances of succeeding are as good as the application. And the whole purpose of administrative review, just so that your viewers understand, administrative review is a process whereby you are asking the Home Office to re-look at your application. There isn't any point in putting the same application again. So your legal advisor will construct an argument against the Secretary of State's reasons for refusing your application in the first place.
Can I add one more question? Can we rely on any further evidence in the admin review or no?
Well, there's something called the flexibility principle that you find in all the guidance notes in relation to Tier 1 application. The flexibility principle applies where the Secretary of State has a discretion. And that discretion is that if there are new documents that were missed out for some reason, and you provide a very good reason as to why they were missed out, then the Home Office, the Secretary of State for the Home Department can consider those documents at administrative review stage.
But if the AR is refused, then we have got right to get GR, right?
Administrative review, if the application is refused and you've addressed everything thoroughly, then you will seek advice from your lawyer as to whether there are grounds on the judicial review. And you have grounds, for instance, if there's an unreasonable decision. So, for instance, we were talking during the break, and you said, I've just had a Tier 1 application that's been refused, and I can't see any good reason for it. Then in those circumstances, you seek legal assistance, you get judicial review, counsel will often draft the papers, the application's made usually to the upper tribunal, and then the upper tribunal will consider whether there are grounds that have merit to argue at a full hearing.
This is the last question, not least, but if the GR refuse, because the client is not in the UK, he's abroad, and he made the application refused, gone for admin review, they refused, they go for GR refused. So can we go for the oral hearing in the absence of the client is not in the UK?
Well, of course,
if there is any.
you can have all hearings in the United Kingdom without the client being there.
Right.
In many hearings, in absence, hearings can be held of the principal claimant or appellant. Unless they are required to give evidence, and if they are, because you can
procedurally, yes, we can go, right?
Procedurally, you can call evidence even in
We really
judicial
much
review.
appreciate. Let us take the call. Hello, yeah, please.
I was going to say that if you're having evidence from overseas,
Yep.
video links can be arranged.
A lot of calls on the waiting. Hello. जी प्लीज कॉल थ्रू करें. हेलो.
हेलो
जी फरमाइए.
अस्सलाम वालेकुम जी.
जी वालेकुम सलाम जी.
मेरी बेटी जो ब्रिटिश पासपोर्ट होल्डर है, अगर वो डेनमार्क से जाकर अपने हस्बैंड का वीजा अप्लाई करे पाकिस्तान से, तो अपना जब ये ब्रिटेक्स होगा, जब ब्रिटेन जो है यूरोप से निकलेगा, तो उसके ऊपर इफेक्ट पड़ेगा उस एप्लीकेशन का?
ऑफ कोर्स ये यूरोपियन लॉ ये कहता है कि अगर कोई भी यूरोपियन नेशनल किसी होस्टिंग कंट्री में जाके वहाँ पे सेटल हो जाता है, काम करता है और वहाँ पे अपनी फैमिली को इनवाइट करता है, तो जो उस कंट्री के लॉज होंगे उसके मुताबिक वो वहाँ पे रहेगा, लेकिन उसको ये साबित करना पड़ेगा कि वो वहाँ पे रहते हुए जो अपने यूरोपियन टीटी राइट्स है वहाँ पे एक्सरसाइज कर रहा है. अब जो सेकंड लिंक क्वेश्चन है कि ब्रेक्सिट के बाद क्या होगा, ये अभी गवर्नमेंट क्लियर नहीं है, तो मैं शायद एडवाइस नहीं कर सकता. मैं आज के लॉ के मुताबिक जो रोज़ हैं उसके मुताबिक बात कर सकता हूँ कि अगर वो किसी भी और कंट्री में यूके से बाहर अगर वो डेनमार्क में काम करती है, वहाँ पे रहते हुए अपने हस्बैंड को बुलाना चाहती है, तो वो बुला सकती है और वहाँ पे वो अपने यूरोपियन टीटी राइट्स रख सकते हुए उसकी एप्लीकेशन कंसिडर की जाएगी. आपकी कॉल का शुक्रिया. लेते हैं नेक्स्ट कॉल. जी फरमाइए. हेलो.
हेलो.
जी फरमाइए. हेलो जी, आपकी आवाज आ रही है, लाइव है. सवाल क्या भाई मेरे आपके?
राजगुल साहब, मेरा एक क्वेश्चन है. मेरे एक दोस्त इटली से यहाँ मूव होना चाहते हैं. उनके अपने पास इटली की नेशनैलिटी है,
राइट.
उनके बेटे के पास भी इटली की नेशनैलिटी है और उनकी वाइफ के पास 5 साल का रेजिडेंस स्टे है. तो उनको क्या स्टेप्स लेने होंगे? बस यही मेरा क्वेश्चन
They can come to the United Kingdom without much difficulty. As an EA national, he has the right to bring his spouse to the United Kingdom with him, and of course she's part of his household, so even if they haven't had a marriage under Italian law and she's had a marriage, an Islamic marriage as a cohabitee of a number of years, she can come to the United Kingdom with him, and so this is a very, very straightforward freedom of movement that can be exercised.
मिसेस नबीला बैरिस्टर हैं, वो काफ़ी लॉन्ग टाइम बोल सकती हैं, उनके पास नॉलेज है, लेकिन मैं आपको शॉर्ट 2 चीज़ें बताता हूँ. सो टू इंटरप्रेट मिस नबीला, आपने 2 काम करने हैं. कोई भी यूरोपियन जब वापस यहाँ पे आता है तो अपने साथ स्पाउस को लेके आ सकता है, लेकिन आजकल कुछ प्रॉब्लम हो रही है कि वो एट द पोर्ट पे उनको स्टॉप कर सकते हैं. इसलिए आइडियल है कि उसका वीज़ा अप्लाई किया जाए और वो वीज़ा लेके यहाँ पे आ सकते हैं. ऑफ कोर्स उनकी शादी हुई है, उनके पास अकोमोडेशन है और यहाँ पे आने का मकसद यहाँ पे इस कंट्री में परमानेंट रहना है. ये 3 चीज़ें पूरी करेंगे तो वो अप्लाई कर सकती है, लेकिन बेस्ट है कि आप किसी वकील को मिलें और एडवाइस लें, उनकी एप्लीकेशन करें. वीज़ा लेने के बाद आना चाहिए, ना कि वो साथ ट्रैवल करें. आपकी कॉल का शुक्रिया. लेते हैं नेक्स्ट कॉल. जी फरमाइए. बिस्मिल्लाह, काफ़ी लोग हैं कॉल पे, सब लेट मी डू जस्ट शॉर्ट. हेलो जी फरमाइए. जी वालेकुम सलाम.
वकील साहब बात कर रहे हैं?
जी बिल्कुल, आप लाइव हैं, सवाल पूछे मेरे भाई.
जी सर, मेरी वाइफ का वीजा लगा था, स्पाउस वीजा 27 नवंबर 2013 में.
राइट.
फिर मेरी वाइफ यूके आ गई थी 2014 20 फरवरी को.
हाँ जी.
2019 20 फरवरी को उनको 5 साल पूरे हो जाएंगे
जी.
क्या हम जनवरी में उनके लिए विंडो सर्विस जो वीजा एप्लीकेशन है वो हम अप्लाई कर सकते हैं जनवरी के अंदर? और क्या हम दिसंबर में अपॉइंटमेंट ले सकते हैं जनवरी के लिए?
ओके, ये दोनों टेक्निकल सवाल हैं. 24 तारीख से ये लॉ चेंज हो रहा है कि प्रीमियम सर्विस खत्म हो रही है. सब लोग एप्लीकेशन किया करेंगे और उसके बाद फास्ट ट्रैक वाला रूट अप्लाई किया जाएगा. आप दिसंबर के एंड पे चेक कर लेना, अगर ये आपको प्रीमियम सर्विस वाला अवेलेबल हुआ तो अप्लाई करना, वरना आपने जो प्रोसीजर होगा उसको फॉलो करना होगा. जो सेकंड सवाल था कि वो कब कर सकती हैं, ऑफ कोर्स जब वो यूके में आई थी उससे 5 साल पूरे काउंट होंगे. अगर तो उसका वीज़ा एक्सपायर हो रहा हो तो 28 डेज पहले अप्लाई कर सकती हैं. अदरवाइज जिस दिन वो यहाँ पे इंटरव्यू हुई है उसके 5 साल पूरे होने के बाद अप्लाई करना वो आपके लिए ज़्यादा बेस्ट होगा. आपकी कॉल का शुक्रिया. लेते हैं नेक्स्ट कॉल. जी फरमाइए. हेलो
हेलो
जी फरमाइए.
मुझे थोड़ी सी इंफॉर्मेशन चाहिए थी. मेरे पास
लीव टू रिमांड इंडेफिनेट स्टे है, लेकिन मेरे ऊपर पुलिस केस थी, इसके लिए मैं कोई जेल में गया था, तकरीबन 10 मंथ्स मैंने अंदर सर्व किए।
राइट।
अभी मुझे ये पता करना है कि मैं ब्रिटिश पासपोर्ट के लिए कितनी देर के
वीजा कौन से आपके पास?
मेरे पास इंडेफिनेट स्टे है।
मिस नबीला, क्वेश्चन टू यू, किनके
Well,
पास?
the fact of the matter is that when you're making an application for British nationality, the application form asks you whether you have any convictions, and you will have to put forward the nature of conviction, how much when you got what you got sentenced, etc. Now, the reason is that when your application is being assessed, in order for you to achieve British nationality, the Secretary of State has to be satisfied that you're a person of good character. The fact that you have a conviction doesn't automatically mean that you won't succeed in getting British nationality, but it's not. It decreases your.
It's a bar for the time, isn't it?
It decreases your chances if there isn't a period of rehabilitation that has passed. So when you committed that offence, will be relevant to the discretion that the Secretary of State exercises. However, having said that, my experience is where there is a conviction, it usually means that you won't be successful in getting British nationality.
Right. अगेन होम ऑफिस की तरफ से एक चार्ट बना हुआ है कि एक लेस आपका ऑफेंस हो तो 1 ईयर, फिर 3 साल, फिर 5 साल, वो क्राइटेरिया अपने जस्ट कीप इन माइंड कि अगर वो इशू आता है तो आपको उसको कंसिडर करते हुए एप्लीकेशन करना चाहिए। एज मिस नबीला से कि ये डिस्कशन टू द होम ऑफिस है कि इसको ग्रांट करते कि नहीं करते, आपको मिल जाएगी, लेकिन एक टाइम वाला इशूज़ मैटर करेगा कि आपको 10 साल या 5 साल के बाद, क्योंकि आपने अनफॉर्चुनेटली आप सेंटेंस हुए, आपने वहाँ पर टाइम गुजारा, तो ये थोड़ा सा सीरियस मैटर है। कुड बी आफ्टर 5 years नॉट एट दिस स्टेज, ये जस्ट कीप इन माइंड। बट एनीवे, जस्ट टेक द एडवाइस फ्रॉम द सॉलिसिटर, डिस्कस करें।
This is really something that you can challenge. So if your solicitor considers that sufficient time has passed between your conviction and your application,
yes, then.
and then you still get a refusal, and as I said, it's likely that you will, that doesn't mean that you have no avenue to challenge it. There is judicial review exists, whereby you can go to the court, and the court can look at the reasonableness, the grounds on which the Home Office has refused it, and consider whether it was good grounds or bad grounds.
Yep. Next call, please. Hello. Hello.
जी अस्सलाम वालेकुम।
जी वालेकुम अस्सलाम जी।
मुझे ये पूछना है कि हमने बच्चे की शादी की थी पाकिस्तान से।
राइट।
तो उसकी वाइफ आ गई इधर। तो 2.5 साल के होने को थे कि हमने फिर प्री एक्सटेंशन अप्लाई की। तो वो बच्चा काम नहीं कर रहा था, वो स्टूडेंट है, हमने पैसों की बुनियाद पर वो अप्लाई किया था। तो मसला ये हुआ कि इमिग्रेशन ने वापस जवाब दिया कि आपके 6 माह के पैसे पूरे नहीं हुए, थोड़ा सा टाइम कम है, तो ये हमको आप वीजा रिफ्यूज करते हैं।
ठीक।
तो आप अपील कर सकते हैं। अपील की वकील ने, तो वकील ने कहा कि हम ऐसा है कि उस वक्त जब हमने पहली दरख्वास्त दी थी उस वक्त तो हमारे 6 माह नहीं हुए थे, अब हो गए।
ओके।
तो अब हम ऐसा करते हैं कि अपील वापस लेते हैं। और
तो सवाल क्या आपका जी? मैं समझ गया, सवाल क्या आपका जी?
सवाल ये है कि ये तरीका जो पिछले 3 साल में कवर हो जाएंगे। तो दूसरा ये है कि जो आपने NHS की फीस पहले दी हुई है वो उसका क्या बनेगा? ये
आपकी कॉल का शुक्रिया, आपकी कॉल का शुक्रिया, क्योंकि मुझे मेरे पास डॉक्यूमेंट्स नहीं हैं जो आपके वकील साहब आपको एडवाइस कर रहे हैं वो ठीक कर रहे हैं, क्योंकि ये फ्लेक्सिबिलिटी जो रूल्स है वो डिपेंड करता है कि कोर्ट या जज एक्सेप्ट करता कि नहीं करता, क्योंकि द डे यू मेड द एप्लीकेशन यू डोंट मीट द क्राइटेरिया फॉर द एक्सटेंशन एंड नो माई बी यू अगर वो फूल कर रहे हैं आप तो यस आप यू कैन मेक द एप्लीकेशन। लेकिन मेरे ख्याल जो आपके वकील साहब हैं आपको बेस्ट एडवाइस कर रहे हैं, मुझे लगता है कि ये ठीक है उनके सर्कमस्टांसेस में। नाज़रीन, आपका और हमारा साथ यहाँ तक जिन्होंने हमारे प्रोग्राम में कॉल किया उनका शुक्रिया। इस प्रोग्राम में हमने जो ज़्यादा बातें की हैं, लेकिन नेक्स्ट वीक हम प्लान कर रहे हैं कि हम लोग बात करेंगे अगेन डेपोटेशन और ख़ास पर जो आजकल लोगों को इशू आ रहा है वो बिज़नेस वीज़े की एक्सटेंशन के ऊपर या वीज़े जो अप्लाई करते हैं उनको रिफ्यूज़ हो रहा है, इस पे नेक्स्ट वीक बात करेंगे। तब तक मुझे और मिस्टर नबीला को इजाज़त। मिस्टर नबीला प्लीज़।
Thank you very much for having me on the show, Riaz.
Thank you for coming of our show, please. Thank you. Bye.